And let's take you back to one of the stories that we're tracking for you this hour. And this hour now, we give you a sneak peek as to what's happening right now at the High Court in Pretoria. And this is where the convicted murderer and rapist Thabo Bester is, of course, approaching the court requesting access to a laptop. This is in order to prepare for his upcoming deportation case. He's just arrived now in court. And I think our reporter, Chriselda Lewis, set the scene perfectly earlier on with some of those conversations there in terms of what is expected to happen today. Now, of course, he's facing charges also as well of escaping from the Mangaung Correctional Centre in Bloemfontein in May of 2022. And we do know that that case has been set for the 10th of February next year. So we'll be taking you to Pretoria as and when those proceedings get underway, because Bester is today approaching the court requesting access to a laptop in order to prepare for his upcoming deportation case. Now, Deputy Health Minister Dr. Joe Phaahla says the rise of diabetes as a leading cause of death in South Africa is quite alarming. Now, speaking at a media briefing in Pretoria, he urged South Africans to make healthier choices.
The Department of Health has warned that diabetes has become the second leading underlying cause of death in the country and the leading cause among women. Phaahla says lifestyle-related diseases are preventable through healthy living. He urged South Africans to exercise regularly and to avoid the excessive consumption of alcohol and tobacco.
Battle is far from over. We've made some strides. We believe that there is some progress which we have made. As we know, all of the NCDs are exploding. I've mentioned diabetes, cardiovascular, but we also know, especially also malignancies, on significant rise. And we see a number of reports from our own data, but also just anecdotally, as we see, even many of you would be aware that just a few days ago we lost one of our colleagues in government, former Minister of Public Enterprise and Finance, Minister Kodan, who also succumbed from cancer.
In an effort to find preventative measures, the department has also used a levy intended to promote good health, like the sugar tax collected by National Treasury. And it is considering other measures like regulating the consumption of salt and making labels on food products mandatory. Meanwhile, the World Health Organization is investigating the developmental origin of health and diseases.
This is David Barker, who was an epidemiologist, and he had looked over decades at data from here and there, and he recognized that the health of women during pregnancy, and not only during pregnancy but before even becoming pregnant, at the time of conception, that the woman's health and nutritional status appeared to translate into the lifelong health of her offspring.
Government has advised South Africans that early detection of non-communicable diseases is key. Balentle Mthethwa, SABC News, Johannesburg.
Let's take you back now to the Pretoria High Court there and see what is happening, because we just understand that proceedings in the case of convicted rapist and murderer Thabo Bester are about to begin. Let's move you there live.
And these profiling has enforced an injustice process that I am currently incarcerated in. I request the court to take note of my access and disability that is being forced by the respondents in this application. I request that the court give me an opportunity as a human to hear me out, as I request access to state my side and basically defend my main application as the reason for putting this application before the court as an urgent application, Your Honor. Your Honor, my urgency for this application, under Rule 6.12 of the Uniform Rule of the Court, Your Honor, I state that, Your Honor, it's highly impossible for me to meet the practice request the court to accept practice deviations because of the fact that I'm not able to meet the normal required court rules, because of the fact that I have a main application that's already on a normal role, which is under Rule 6. And because this application that I present before this court is to enforce constitutional rights that I'm not able to actually have a defense on the main application, I request the court to consider under Rule 612 that I be granted urgency on the basis of that I have lack of resources to be able to take a normal course. And also, Your Honor, the application is brought by a person that's absolutely under not normal circumstances, Your Honor. And I'll give grounds to the unnormal circumstances that I bring this application before. The main application is of a person that was deported out of a country in Tanzania with false documents issued by the Home Affairs that confirmed that this deportation was not lawful. And in that also, Your Honor, is that my incarceration is also in question. It is also found that, Your Honor, that in this main application, that I cannot further give any context to it because it's a matter on another platform, but on another court. But the issue is fundamental, that I am challenging the lawfulness of my imprisonment, and I'm also challenging the lawfulness of my deportation and my arrest in Tanzania. And in that, Your Honor, I am not able to self-represent myself without having a lack of legal resources. And because of the lack of legal resources, I am not able to defend my main application. I'll take the court into...
What legal resources do you need?
Your Honor, I require access to a laptop to type.
I'm not giving you a laptop in emergency. So I'll give you access to hard copy books, but I'm not giving you a laptop in emergency. You can have access to hard copy.
But Your Honor, you haven't even heard my application. You are making a decision up front.
But you're not giving access to
For what reason, which constitutional reason do you give to deny me access without hearing my application, Your Honor? That is prejudiced of you not to allow me to...
You will get law books. They are the same books that every jurist in the country, pre a certain time when laptops became the norm, used. I used them when I started practice 30-something years ago. They will give you access to all the information you need for purposes of preparation of both your main application and your defense in the Free State. And that is essentially what you are. So you will get access to
Can I finish my application? Can I bring my application before the court?
You can make your submissions, Mr. Bester, with pleasure.
Your Honor, I would like to take the court into the processes that I've gone through to bring this application before the court, and also reason why I've requested for a laptop or access to internet or information, as access to information is a constitutional right of anyone. And also...
You don't have a constitutional right to a laptop and a modem, Mr. Bester.
Can I finish?
No, I'm putting it to you. Show me where in the Constitution says you have a constitutional right to a laptop and a modem.
Your Honor, I do not have a constitutional right to that, but I have a constitutional right to access to court. And the resources can be limited, as a right to an inmate can be limited under limitation. And under those rights, Your Honor, there are access to laptops and modems in prison currently to students. So are you saying that I do not have a right to access court?
A student, Mr. Bester.
No, Your Honor.
I'm giving you access to law books. All the material you need, I will give you access to. They will just not be electronic.
Your Honor, I have evidence in the main application that has to be seen, that is visual evidence, which is press briefings. It's also in the responding papers of the main application where the respondent states that I have not added those press statements that I've put because of the fact that I do not have access to them and I have not watched them. And how am I going to watch them when I'm in CMAX, when I'm incarcerated? And the fact that I have no resources to access those evidence. And the application is based on the following. But Your Honor, you have thrown my application out of court without me giving you background.
No, I actually haven't, Mr. Bester. I'm telling you, I'll give you the material you need. I'm just not giving you electronic material.
That's biased, Your Honor.
Yes.
Because you haven't let me finish why I stated the application.
Mr. Bester, you want...
And you are defending the application as the defendant. You are not giving me an opportunity to justice, Your Honor. You are blocking me. I'm putting my submission. You could allow me at least to finish my submission and then throw it out.
You are welcome to make submissions, Mr. Bester. Okay. As I've said to you, I will give you access to material.
Okay,
you are welcome to.
Can I continue to make my submission?
Mr. Bester, don't be reading my book.
I'm sorry. Can I continue? Can I make my submission?
Mr. Bester, be polite and different in a court of law. Please don't stand there and roll your eyes. It is really unbecoming. We are having a debate here. That is what we are doing. I have given you my prima facie view. I'm going to give you a full opportunity to place your facts before me. But you will need to convince me that you require access to a laptop and a modem for purposes other than what hard copy material cannot give you. That is in your papers, Mr. Bester. All right. Please continue.
Your Honor, I also bring the fact that I'm self-represented in both applications, which is this one. Your Honor, I have lodged the application on the 13th, which was commissioned on the 13th of August. Because of struggling to get third parties to assist me to file the application online, it was very difficult for me to bring this application. As you would see that the respondent used the fact that the delays of dates of the sit-down because of the fact that there were missing applications and missing documentation in my submission. And because of that fact, Your Honor, is that I do not have access to court because I cannot file an application without anyone assisting me. I'm also in a position where I'm disprivileged because of the fact that I have 2 visits a month, which is 30 minutes a visit each month. And I'm also limited to legal resources because every legal counsel that has to see me must make a booking based on availability, then that would be granted. So meaning that if I have to submit or access any information, my resource of accessing information is limited because of the rules and regulations that are enforced on me at CMAX. And because of that, Your Honor, I cannot file an application as I wish. I cannot take any litigational facts as I wish at any point to access the court. The court is digital. And if the court is digital and I have to use a third party to file an application in this court, it makes it impossible for me in my current circumstances. I'm not asking for a free will access to internet. I will showcase the court that access can be limited and can be secured in an environment that I'm currently in. It is proven by other courts and other prisons that has enforced the same laws. And access to court, Your Honor, access to court, Your Honor, is very fundamental to any person that is incarcerated. It is irrelevant or important to insist that only students are privileged. It's discriminative and it's not equality to everyone, because access to court brings fairness to all. Because, Your Honor, without access to court, I cannot fight for my own freedom, and my liberty is at question at this point. And I am requesting the court to assist me to access court. That is all I am asking the court. If the court can make any arrangements that I would be able to access the court, I have no problem. I will state in the following, Your Honor, application. I had requested that head of prison assist me on typing documentations at the center. This application was disapproved. I was informed, and I have a copy of the application, that I was informed that I need to send the application, whatever I handwrite, to someone to type. I have limited resources in reaching those people and also getting to those people to give me those applications and type them and bring them back. By the time I file an application, I would already be out of the time frames that the court requires. And in that, Your Honor, I have placed these issues of access to information of hard copies that took me an average. I was only allowed from November on the 16th by the head of prison and the area commissioner to be allowed to even receive a novel. I am denied access to a diary at the current state that I am. I am denied access to information that involves any information that is printed that brings question of evidence of where it be printed by the media. It's been rejected by the current respondents, Your Honor. I have not been able to access that information. And currently, Your Honor, I cannot in any way access that information. It is proven by the respondents' answering papers in the main application that my papers are incomplete because of lack of evidence. The lack of evidence is fundamental to my liberty. And all I am asking the court, I am not asking for access because it is access to laptop or modem based on the fact that it is the only resource that I need. It can be in any way. It is also proven in a case in 1977.